St. Johns County Circuit Court is now in session. The Honorable Judge Smith presiding.
Good afternoon. Please be seated. Thank you. All right, we're here on case of State of Florida versus Aiden Fucci, case number 2021 CF 825. Who do I have appearing on behalf of the State of Florida?
This is State Attorney Jennifer Johnson.
Mark Johnson, State Attorney's Office.
And on behalf of the defendant?
Rosemary Peoples.
And Craig Addicks.
All right, and Mr. Fucci is also present. We are here on a notice of hearing that was filed by the defense. There were 3 motions in limine that were filed, I believe, on Friday of last week. I have reviewed all 3 of those motions. I also received a case, Barnes versus State of Florida, which is 227 Southern 3rd 216. I've reviewed that case as well, and before we began. Are there any matters we need to address before we start with the first motion from the state?
No, Your Honor.
Anything from the defense that we need to address before we begin with the first motion?
No, sir.
Which one would you like to begin with?
We think to go in the order as presented in the notice of hearing.
All right, so the first motion would be the motion in limine to exclude impermissible sentencing considerations of alleged post-arrest bad acts. I'll hear from you at this time on that motion.
Defense counsel remain at this table or should we approach?
If you'll approach the podium and speak at the podium, please. You may. No, the podium. Yeah, we'll just take it one by one.
Good morning, Your Honor, or good afternoon. So defense is moving on the motion in limine to exclude impermissible sentencing considerations of the alleged post-bad acts. And this is in reliance on Norville v. State, 191 Southern 3rd, 406, and specific pages 408. Your Honor, within that case, it identified that the trial court may not consider subsequent arrest without conviction during the sentencing of the primary offense. And that's what we have a good portion of that the state is trying to introduce through the Jacksonville Sheriff's officers regarding incidents in custody. So we've completed the depositions of defense expert Raul Bonasco and the JSO officers Cox and Anderson. And these allegations, with the paperwork we received, are identified as cleared. But more importantly, Your Honor, these allegations do not carry any form of conviction. So what we're trying to do is prevent that consideration in that testimony coming in before the court, as it's an impermissible consideration. So with that in mind, we're asking the court to prohibit state witnesses' testimony about these allegations of the ongoings within the county jail, within the Duval County Jail.
Are these criminal allegations that are uncharged, or specifically what type of allegations are we talking about?
Yeah, yes, Your Honor. That allegations of threats of violence, and because they weren't pursued and that there was no conviction with any of these, is the issue that we have at this juncture with this particular moment.
All right. Anything else?
No, sir.
All right. Thank you. State in response.
Yes, Your Honor. The post-arrest alleged bad acts that Ms. Peoples is referring to is this jail behavior. He was not formally charged. It includes acts such as other threats of violence to inmates and guards. It includes other acts of manipulating inmates out of commissary, and some behavior when approached by guards in the jail and resisting both physically and verbally their commands. All of that information that we're attempting to rely on is not under the bad acts that Your Honor normally considers under 90.404 if we were in a trial posture. We are attempting to use that information through psychologist Dr. Pritchard. He specifically relies on it as relevant to factor J, which is the possibility of rehabilitation of the defendant. And outside of just that specific factor, Judge, if you look at that Norville case, the state provided Barnes, which Norville was not a juvenile. So that was an adult defendant that they were considering sentencing under general sentencing statutes. Barnes specifically states that the defendant in this case, Barnes, was a juvenile and proceeding under 921-1401, which is what we will be proceeding under, and Your Honor is to consider before sentencing this defendant. This court said in relation to the juvenile, the reliance on Norval is misplaced. He's a juvenile offender and subject to the new statutes enacted for sentencing juveniles, specifically convicted as adults. The court says these statutes allow the trial court to consider juvenile offenders' youth and its attendant characteristics, which Dr. Pritchard also references these acts under. And that includes the juvenile's immaturity, lack of judgment, possibility of rehabilitation, in determining whether Your Honor should impose a life sentence. And the court goes on to say that his, meaning Barnes' subsequent criminal behavior is equally relevant to help the court determine his immaturity, impetuosity, or failure to appreciate risk and consequences, and any other characteristics attributable to this defendant and his youth. So in Barnes, under these specific sentencing structures, which is much different and more specific than a general adult sentencing, it appears that it is relevant and we're not held to just a criminal conviction as far as bringing up behavior, both pre, which will be the next motion, and post. It's essentially a similar argument, Judge.
Response?
Very briefly, Your Honor, looking at the state's case of Barnes v. State, the distinction is made to 921.1401 that his subsequent arrest with conviction, and that is stated multiple times within the opinion, may help the sentencing court determine whether Barnes was a juvenile offender whose crimes reflect transient immaturity. And that's the distinction that we have in this particular instance. These are allegations without conviction. And that's what it's similar to Norval, that yes, under 921.1401, the court can consider other acts, but what they're trying to do is introduce acts without conviction. And that's impermissible, and that's what the defense motion is arguing, that it does not even meet by a preponderance of the evidence, the allegations that are before the court, or that the state would like to present before the court, and the case law does require with conviction. So with that being said, defense would ask the court to not permit these impermissible considerations at the sentencing hearing this week. Thank you.
State, take me through the Barnes case and help me follow along with your argument as to why and at what point they're no longer referring to behavior with convictions, subsequent criminal behavior with convictions. I read it as it states, and I'll just read it out loud, at a minimum, Barnes' subsequent criminal behavior with convictions is relevant to the possibility of his rehabilitation. And then what you referred to, it goes on to say his subsequent criminal behavior is equally relevant to help the trial court determine his immaturity, impetuosity, or failure to appreciate the risks and consequences in participating in the offense, and the effect, if any, of characteristics attributable to the defendant's youth on the defendant's judgment. But then it goes on to say, simply put, his subsequent arrests with convictions may help the sentencing court determine whether Barnes was a juvenile offender whose crimes reflect transient immaturity, thereby warranting a lesser sentence, or that rare juvenile offender whose crimes reflect irreparable corruption, thereby warranting a life sentence. Doesn't that last portion seems to indicate that what the Fifth District Court of Appeals said in Barnes was that it really is just allowing for the court to consider post criminal behavior with convictions. And I know it's kind of new ground here, but
Right, I don't read it that way, mainly because I understand what you're saying, because Barnes did in fact have convictions. So they do make the point that, yes, his criminal actions with convictions may help, but they begin the analysis by stating that the entire argument of Barnes on Norval is misplaced. So Norval does not apply to the circumstance, and now they're analyzing how a juvenile should be sentenced, and they say Barnes is a juvenile and he's subject to new statutes for enacting juveniles, for sentencing juveniles as adults, and it goes on to say it allows the court to consider these other factors that wouldn't normally be considered necessarily in an adult scenario. And then I think that qualifier, at a minimum, his subsequent behavior with convictions is relevant. So they're acknowledging that absolutely at a minimum, the conviction is relevant. And then the next sentence just states simply, his subsequent criminal behavior is equally relevant. Equally relevant. So a juvenile's subsequent criminal behavior is equally relevant to help the court determine all of these factors. And then again, they make the point, he has convictions. Yes, they absolutely should be considered, but they clearly distinguish a normal adult sentencing and rules that Norval set out from what they want to do with juveniles, and then comment that subsequent criminal behavior is relevant to help the court make these determinations, and state at a minimum his conviction or his behavior with convictions is certainly relevant. So I think they're speaking beyond just Barnes, who had convictions with his behavior. I think they're making the point that juveniles are different, obviously, and all of those factors that set forth anticipate all kinds of behaviors in a defendant's background, both pre and post, so long as they're relevant and material to a factor that the court can consider. Now, if they weren't psychologically or otherwise relevant to one of the factors, perhaps the court couldn't or the state couldn't put them in, but we have a witness who will tie them directly to factors that the court should consider in sentencing him. So for those reasons, we believe they are relevant, and we believe Barnes stands for the proposition that they are for juveniles.
All right, thank you. Let's move to the next motion at this time. So this would be the motion in limine to prohibit prior bad acts.
Thank you, Your Honor. The defense motion in limine to prohibit testimony of alleged prior bad acts, it's looking at, again, impermissible allegations or evidence before the court as sentencing. So in this particular instance, there are allegations of wrongdoing within the school that resulted in in-school discipline, not in arrest, not in convictions of any form. So we're asking the court to not allow those bad acts, or alleged bad acts, I should say, Your Honor, to come before the court. That the prior record can be considered, but the prior record that can be considered would require a conviction. So what is occurring in this particular instance, or what we're trying to protect, is his constitutional right to a fair sentencing hearing, and not allow these impermissible factors to come before the court at the sentencing hearing. And we would argue that it's impermissible to have the allegations, and primarily I believe the state would try to introduce those through Dr. Pritchard, have those come before the court, and I understand that they're using that in support of their view of 921.1401. But again, we're not dealing with prior convictions. These aren't issues that have even been resolved by a preponderance of the evidence, Your Honor. And then our ability to cross-examine on these issues is greatly diminished because of the nature of these allegations. They're in school, they're at most resolved with some form of discipline, meaning detention, and at one point maybe a suspension. But they're not the kind of bad acts that rise to the level where law enforcement's contacted, arrests are made, a 707 is put together, or even with the juvenile justice system, the paperwork that would be generated there. So in light of the evidentiary issues that would be brought to fore with these types of allegations, we're asking the court to not allow these prior bad acts, these alleged prior bad acts before the court at the sentencing hearing, and allow them to have a fair sentencing hearing. Thank you.
Thank you, counsel. State.
Your Honor, it's a similar argument in the prior bad acts that it's really prior conduct that the state would intend on using as an array of school behaviors, not just disciplinary behaviors, But that included, which ranges from anything from, disrespect to fighting to threats and things like that, but also general conduct in school, and how Mr. Fucci behaved. In this instance, again, we're not choosing to admit them. They're not coming in under 9404 or anything like that, where we're intending to prove motive or anything related to the crime. These are relevant to sentencing factors, according to Dr. Pritchard, C and E. C has to do with his age, maturity, intellectual capacity, mental and emotional health, the effect that any of that has to do on his failure to appreciate risks and consequences. So it's quite clear that general school conduct of any individual tells a lot about someone. These teachers testified about how much time, obviously, that they spend with these kids. They knew Mr. Fucci very well. All of those conduct, good and bad, surrounding Mr. Fucci as a student, decisions he made, whether he could appreciate the consequence of disobeying an order in school. It all goes to direct factors and tells you more about Aiden Fucci. I guarantee you, if Aiden Fucci had been an all-A student with academic achievements and character awards, that would all be, and it would be proper. The state would have no argument that all of that would be relevant, good or bad, under C or E, to describe Aiden Fucci, and especially by a psychologist, relating to how he appeared emotionally and mentally at that time, and how did that affect the crime that he committed. So whether his conduct in school, and there's aspects of it that I'm sure Ms. Peoples will present and point out that are positive. So positive or negative conduct tells a lot about this defendant and this student and who he was at the time at 14 years of age when he committed this crime, specifically to subsection C and E under the statute. And it's absolutely relevant for the court to consider who he was prior to and at the time of committing this crime. So for those reasons, we believe that type of evidence, school conduct, school disciplinary issues, will be relevant in sentencing.
All right, thank you. Any response?
Your Honor, the prior conduct that the state's trying to introduce is not concurrent. It's not at that within a month or a day or two. It's issues that track back to 3-4 years in school in certain instances, 5th grade, 6th grade, 7th grade. So I understand the portions of the statute that they're citing, but it doesn't apply. It's not an issue of bringing in certificates that he might have received in 5th grade or 4th grade. It's a matter of trying to introduce prior bad acts that don't qualify. These are not prior bad acts with a conviction, or even to a lesser, as I said, even to a lower standard, maybe to a preponderance. These are prior bad acts that we don't have much of an ability to counter in terms of the documentation. They're in-school infractions, so to speak, that the school had dealt with inside the school to resolve. They don't rise to the level of criminal conduct, but yet the tone or the flavor that Dr. Pritchard will describe them will be. So in nature of the intended testimony about prior bad acts, in absence of a conviction or arrest, we're asking the court not to allow that at the sentencing hearing, where there's, again, I'm repeating, but there's no conviction or arrest, and to say that it qualifies under 1401 subsection C or E, it does not. It does not, Your Honor. This is an attempt to bring in something that would not qualify as a prior criminal conduct. And for that reason, we're asking the court not to allow it at the sentencing hearing and allow him to have a fair trial, fair sentencing, I would say. Thank you.
All right, state, yeah, something else?
Just the only thing I would add for the record is the people that provided this information have been deposed by defense. She has every opportunity to call them. If there were other juveniles involved in this conduct, they were named and identified. So I just don't agree with the stance that she has no ability to react or present evidence on these. These teachers have all been deposed, like I said, and she has equal access to them as we do.
All right. Let's move to the final motion. This is the motion limited to prohibit the testimony of Dr. Gregory Pritchard.
Yes, Your Honor. Defense would move in limine to prohibit the testimony of Dr. Pritchard. State expert Pritchard was deposed on Wednesday, March 15th, and his testimony or his anticipated testimony would be on reliance of the discovery materials, meaning the depositions, the crime scene investigations, autopsy investigation. And at no point is his reliance or his testimony going to be on the foundation of prior mental health evaluations. We know from the school records that there aren't any. So his testimony then wouldn't be within his field of expertise as a psychologist. Really what his testimony would be is a regurgitation of the discovery. And for that reason, Your Honor, we'd argue that it's improper for him, with his unsupported opinion, to testify before the court regarding the deposition transcripts, the crime scene photos, the medical examiner report. And his testimony, as anticipated, would be devoid and would then, in essence, Your Honor, mislead the trier of fact. Because what he's doing, Your Honor, in terms of what we would usually see with a mental health investigator or a mental health expert, would be some form of review and analysis of other reports, evaluations. But there aren't any in this particular case, and although it's heavily relied, he was only 14, and it's heavy reliance on pediatric records or the actual school records, there aren't any psychological evaluations. So what he's relying on instead is what he has are depositions, police reports, and the medical examiner report. And defense would argue that would be inappropriate for psychologists to come before the court and then opine as a psychologist about the nature of the offense based on photos and the medical examiner. So for that reason, Your Honor, asking the court to prohibit the testimony of Dr. Pritchard in this particular sentencing hearing that begins tomorrow. Thank you.
Thank you. State.
Your Honor, this argument by Ms. Peoples is quite unbelievable, and I'm sorry to say disingenuous. Ms. Peoples is extremely experienced and aware of what experts can rely on and use in criminal cases, forensic, psychologists. Both parties do this in our careers on a daily and monthly basis. And Ms. Peoples is well aware that mental health experts largely rely on and review records where we weren't forced to file in 40. There were times where the state didn't get the opportunity for the mental health evaluation if we didn't follow a certain set of rules. It never limited the state in calling a mental health expert based on an extensive record review. Dr. Pritchard also testified it is quite common in his practice that he will often be faced with uncooperative defendants maybe who are claiming insanity, there's competency issues with. And if, he's not saying he would make an opinion in every case, but if there are enough records there and they're comprehensive and he's able to make an opinion on certain things, he will opine, and if he's not, he will state his limitations. And his report right off the bat states, please understand these opinions are stated with the limitation I have not spoken to him. He makes no diagnosis because he did not speak to him. But that is not the end. Just because Ms. Peoples chose, as she says in paragraph 3, the defense has discretion on how to present sentencing mitigation. Sure. And they chose initially not to present mental health mitigation, or traditionally what would be considered mental health mitigation. That doesn't mean it ties our hands in a juvenile sentencing under Miller-Graham and the Florida statutes that were developed after Miller-Graham. It's very clear that Florida legislature made mental health an issue with juveniles, emotional health, maturity health, intellectual. And Rule 3.78 1, I believe, B, is very clear. 3.781B allows both sides to present equally evidence on these factors. So we are not in, you know, I keep going back to, because it's just how she keeps framing it, we are not under the death penalty statutes where the state is limited by 16 aggravated factors, none of which have to do with mental health. They're very specific. We have to stay over here unless and until something is triggered by the defense. That's not where we are. We are under 921, 1401, where mental health is very clearly, and all the other psychological issues within those factors is put at issue. And the rules state that both sides will have equal opportunity to present evidence on those issues. So this is very, very different. Just because he's not made a face-to-face evaluation doesn't mean he doesn't have enough information to make a psychological opinion, and he made one where he felt like he could. And again, like I said, he testified that he had enough in this case, and this is not uncommon. Of course he would prefer to evaluate him. We deposed Dr. Bloomfield an hour or two ago. Her expert said he's on a couple of the factors say that no expert can do this without a face-to-face eval when her own expert opined on some of these factors because he had enough there. There are numerous teachers, deans, students, friends, family. There is a volume of information on Mr. Fucci. Would it be better or best if we were able to evaluate him? Of course, we would have loved to be able to evaluate him, but she didn't allow that, and that's fine. But that doesn't cut off the state's hands and tie our hands from being able to present evidence that's relevant to these factors if there's something for the expert or anyone to opine on. The state, you know, there's teachers, there's lay people that have opinions on these issues that may or may not call for an expert opinion. It would be no different if we were calling all of them in. If it's relevant and material to a factor the court's to consider it, then it should be allowed. Otherwise, I'm not sure what the court's going to consider, other than the nature and nature and circumstances of the offense. If you look at those factors, there's the nature and circumstances of the offense, the effect on the victim's family, and the other 8 all have to do with Mr. Fucci and who he is. And if the state's hands are tied, that's not the intent of the statute. That offers your honor not a lot of information in order to make your decision. That the legislature is very clear, because our Supreme Court has said juveniles are different. So therefore, you have to do an individually